Good morning, Judge Patel. I do not see Attorney Mark Sands in the gallery, and I've tried the phone number to contact their office, but it's just a voicemail. So I wasn't sure if you had a different number, if your chambers had a different number for him that I do,
Uh,
but
Good morning. Let me go. Mr. Sednick, do you have a number that you can reach Mr. Sands at? Your audio is still off.
May unmute. Okay,
There you go.
Okay, thank you. Good morning, Your Honor. I know that he
he just got in. Sorry to
Okay,
interrupt you.
wonderful.
He
All
just
right,
got in.
thanks.
Yeah, thanks.
Morning, Your Honor. My apologies. Technology and I are not always friends.
No worries. I experience the same sometimes. So good morning to everyone here. We are to this session of the Michigan Court of Claims. I'm going to call the case number. It's case number 23-144, Raytheon Martin versus the Michigan Commission on Law Enforcement Standards. Could I please have the attorney's appearances for the record?
Yes, Your Honor. Mark Sands, Assistant Attorney General for the Michigan Commission on Law Enforcement Standards.
Okay.
Good morning, Your Honor. Peter Sudnick, appearing on behalf of the plaintiff, Ray Martin.
Okay, great. We are here today on defendant's motion for summary disposition. Mr. Sands, would you like to proceed?
Yes, Your Honor.
Okay.
Good morning. An issue in this case is whether any act or omission by the commission caused Mr. Martin's law enforcement license to lapse on June 3rd, 2021, and as a consequence for Mr. Martin to lose his property right in that license. The answer is simply no. And that's because there's a difference between employment and licensing for law enforcement. The commission doesn't have any oversight authority over the employment decisions of the Detroit Police Department. DPD employs dozens of non-sworn individuals who are not subject to any regulation by the commission. Here, DPD made an employment decision to remove Mr. Martin's law enforcement authority on June 3rd, 2019. Once that happened and we're notified, his license automatically becomes inactive by force of law under the MPOLS Act. The commission's function to hit the deactivate button is wholly ministerial. Receives notice of the removal authority, records it in the system to memorialize the date the authority is removed. And it's important to note that the removal of law enforcement authority is not necessarily an adverse employment action. There are any number of reasons an individual might have his or her authority removed. Long-term illness, injury that impairs their ability to do the job as a police officer, employment in the armed forces are three of the more common ones. So, for instance, if an officer broke his hand and wasn't able to use his firearm, his department or her department may remove their law enforcement authority and assign them to an unsworn position. That officer will stay on inactive status until one of three things happens. First, they maintain employment with that department, and the department notifies MPOLS that they're reinstating law enforcement authority. They separate employment or go to a new employer, then MPOLS receives a request to reactivate that license. The new employer will administer the oath of office and submit an affidavit stating that.
Mr. Sands, can you point me to the part of the statute that you're referring to for this authority?
Sure, it's MCL 28609. I never remember if it's 10 or 11. I believe it's 10 for.
Yeah, 10 deals with inactive and when it can be reactivated, and 11 is lapsed.
Yes.
Okay, so are we in the lapsed section right now that your argument?
Because we're within.
Not you're still in inactive.
Right. So what happens is Mr. Martin has more than 2,080 hours of law enforcement experience. When his law enforcement authority is removed under 10B, he is inactive for 2 years. During that time, one of two things can happen.
So I'm gonna stop you there again because I want to talk about this section.
Okay.
because the language in the statute says is continually subjected to a removal of the authority conferred by the oath of office for less than 2 years, correct?
Yes.
So what is your argument that he was subjected to the removal of the authority conferred by the oath of office for less than 2 years?
Because Detroit Police Department notified the commission that it was removing his law enforcement authority in June 2019.
Okay.
So that
What about the subsequent actions by the department? Maybe not dealing with the notice that it provided to MCOLs, but with the with their conduct with Mr. Raytheon, where he was reinstated and you know, albeit with administrative duties, et cetera. But how does that impact your client and like the client's duties and where, because and please feel free to educate me, but the way that I am interpreting the salient issue in this case, the first is whether we're dealing with an inactive license or we're dealing with a lapsed license. Like the two are they're very different in terms of the procedures that would be involved in reinstatement or initiation. Is that correct?
Yes, it is.
Okay. And then, so going from there, what is the argument that Mr. Raytheon's, Mr. Martin's, license was lapsed as opposed to being inactive?
Because it wasn't reactivated within 2 years. So under section 10, the license stays inactive for 2 years. And after that 2-year period, under section 11, it becomes lapsed.
Okay, then let's talk about section 11 then. Point me to the wording in the statute that you're relying on for the proposition that as a matter of law, the expiration of the 2 years is going to render an inactive license for over 2 years is going to render it lapsed.
Sure. A license issued under this section is rendered lapsed without barring further licensure under this act if one of the following occur. Subsection D, an individual having been employed as a law enforcement officer for 2,080 hours or longer in aggregate is continuously subjected to a removal of the authority conferred by the oath of office for 2 years. And that's what occurred here, because he was never his authority was never reactivated with the commission under either section 8.
Well, but the language, and this is where I am, even though I'm pressing the point because I have I need clarification on it and an education on it because I'm fairly new to this case and not super familiar with the procedures. But it says continuously subjected to the removal of the authority conferred by the oath of office for 2 years. According to my notes, Mr. Martin was returned to full duty May 19th, 2021, which is before the expiration of that 2-year period, right? I think the salient date was June 2nd, 2019. For when I'm sorry, go ahead.
I said, yes, that's correct.
Okay. And then, by the last chance agreement, he was returned to full duty as of May 19th, 2021.
That's our understanding as well.
Okay. So that is before the expiration of 2 years. So what is your response to the argument that he was technically not subject to the removal of authority conferred by his oath of office because he had been reinstated as a police officer?
Because the MCOLS Act tells us how that authority is reinstated, and it's under section 8B. The employer has to report to the commission that the individual's law enforcement authority has been restored.
Well, hold on. So we're going to 8B, did you say? So that section states a law enforcement agency that has administered an oath of office to an individual under this section shall do all of the following with respect to that individual. And then B says, report to the commission regarding or concerning any action taken by the employing agency that removes the authority conferred by the oath of office or that restores that individual's oath of office or authority. So that section, at least from my reading of it, talks about what the agency is supposed to do with respect to their communications with MCOs, but it doesn't speak to whether the legal question, which is, was by operation of law, Mr. Martin's license rendered inactive or lapsed?
Well, respectfully, Your Honor, I think it does, because what Section 8B tells the agency is how, the way that they restore the authority conferred by the oath of office, and that's by notifying the commission that it's done so that the commission can activate its license, and so that there's a record that the individual is authorized to enforce the criminal laws of the state of Michigan. Otherwise, before his license is activated, Mr. Martin had the same arrest authority as a citizen, and that is extremely limited. That doesn't include the right to use force. And that's what occurred here. Is Detroit didn't do what it needed to do to reactivate his license. And so the time that his license was inactive kept ticking until June 3rd, 2021, at which point, by operation of law, it expired.
I don't know that I'm finding support for that proposition in Section 8B, because Section 8, from my reading of it, and 8B talks about a reporting duty, the agency's reporting duty. And Section 11 and Section 10 and 11 talk about what makes a license inactive or lapse as a matter of law. And I don't know that I see a nexus between the agency's reporting duty to MCOs with the operation of law on whether the license is rendered inactive or lapsed.
Because they have to notify the commission of those acts, because the commission is the agency that issues the license. This is really no different than somebody who's a barber, who has a barber's license, who gets fired, who gets rehired. If they don't reinstate his barber license, they can't be a barber. They don't reinstate his law enforcement authority, he can't be a law enforcement. That's what happened here.
So what about the pronouncements by the DPD that he was reinstated with authority pending getting his license?
Well, what they did was because the time ran out, there's a process for what happens when your time runs out, your license lapses, and that is you apply for new licensure under the recognition of prior training and experience program. Mr. Martin applied for that. Mr. Martin's application was denied. And there's also an appeals process for that. The appeals process for that is found in the revised Judicature Act as a non-contested case. So what happened was, because they didn't reactivate his license and it got lapsed, he was required to apply for a revised the training program. And what that does is that allows people whose license have lapsed or were police officers in other states, certain tribal officers, to not go to a basic training academy because they've already been to a basic training.
Mr. Sands, if I disagree with you that Section 8 impacts the underlying legal issue of whether the license is lapsed or inactive by operation of law, do you have another argument for why Mr. Martin's license was lapsed as opposed to inactive?
Well, the other reason why it's lapsed is in the record that he was terminated. Now, what happens, there's a different procedure when someone separates from employment from their agency versus when they're continuously employed and are subject to a removal of their law enforcement authority. When you're continuously employed, subject to a removal, that's where 8B comes from. When you're separated and then rehired, as occurred in this case.
Are you referring to the termination, the March 18th termination?
Yes, Your Honor.
So wasn't that revoked as a matter of course when the last chance agreement was entered into, which basically said, okay, this is not a termination, it's going to be a 30-day suspension, et cetera. It basically revoked that termination.
Well, I think
for
what
legal.
it did is there was a termination. Once that termination happened, the license also, that's also an event that causes a license to be enacted. So in that instance, and because it was already enacted, there's different procedure to reinstate a license where there's been a separation of employment. And that is the agency has to apply for reactivation under section 10B. They only have to look at certain aspects of the licensing standards, one of which is character fitness, which is an issue here. And then what they do is they submit the oath of office and an affidavit attesting that the individual meets the licensing standard. The commission reviews that, and the commission does one of three things. They either agree that the individual meets licensing standards and issues the license. They find the individual doesn't meet the licensing standards and doesn't issue the license, or they can supervise additional screening to ensure compliance with those standards. So the fact that he was terminated means Detroit would have had to submit a reactivation request under 10B.
Can we still call it a termination though, since it was then per the last chance agreement, that at least from my understanding, that termination was basically scrubbed and it was turned into a suspension without pay.
But he was separated from employment from the date that he was terminated until that termination was changed.
Okay.
And so that's what triggers the reactivation requirement of 10B. And in which case Detroit still didn't didn't have him apply for reactivation within that 2-year period because he was continually subjected to the removal of his law enforcement authority. He did not have law enforcement authority until after the license lapsed.
He may not have had full law enforcement authority, but he had law enforcement authority.
I disagree, Your Honor. It is, you have law enforcement authority or you don't. And you have law enforcement authority by having an active license from
Because the going to the I'm just looking for the language in the agreement. Which states Sergeant Martin, pursuant to the last chance plea agreement, was reinstated on May 19th, 2021 to full duty with police powers.
Right. So they said they were going to do it, but they didn't actually do what they needed to do to make that a reality. They didn't provide MCOLS with a notice that they were restoring his police powers before the time to do so expired. And so he didn't have an active license.
He may not have had an active license, but he was employed with the police department and per this agreement had been reinstated with full duty with full police powers. So I'm trying to square that with 28,609, 10 and 11, because I think that there's a big difference between whether his license was inactive and Mr. Martin needs to go through, or the DPD needs to go through the procedures in subsection B, 10B to reactivate versus if the license had lapsed. And under the lapse statute, it says is continuously subjected to a removal of the authority conferred by the oath of office for 2 years. So that's, that's 11D.
Yep.
And so I guess my question to you is how are you interpreting 11D, how are you interpreting 11D and the language in the last chance agreement that says that he was returned to full duty with police powers?
Because DPD didn't inform the commission that he was being restored to police powers, which allows us to activate his license. And having an active license is required under section 14 to exercise the law enforcement authority.
So I looked at section 14 because I thought that might be partially what you were relying on to say that his license had lapsed. But what my question with section 14 is, do you see a distinction between exercising law enforcement authority versus the language in subsection 10, which in 11, which talks about authority conferred by the oath of office?
I think that's a problem. So they purported to confer the authority. He couldn't exercise it because he didn't have an active license. You confer the authority by informing MCOLs that this individual is active, does have law enforcement authority. They activate the license, and then they're allowed to exercise the law enforcement authority.
So in your understanding, DPD or any police agency would have to confer the authority first and then contact MCOLs to reactivate the license in order to have the power to exercise that authority.
That's correct.
And so there's a distinction between having the authority conferred on you versus having the right to exercise that authority.
I don't think there's really a distinction, Your Honor, because again, law enforcement authority is something you have or you don't. And you don't have it until you have an active license.
But section 14, which is the subsection that you're relying on, doesn't talk about having the authority or not having it. It talks about exercising the authority.
Right, and you can only exercise it if you have it. And he doesn't have it until the license is activated.
Please continue with your argument. I've peppered you with enough questions.
Well, I would be happy to answer any other questions. Otherwise, we would just rely on our brief, and I'd be happy, of course, to do a rebuttal after Mr. Sudnick goes.
You will have plenty of time for rebuttal. Thank you, Mr. Sands. Mr. Sudnick?
Okay, thank you, Your Honor. And Mark, good morning. We have pleasant conversations between us, so that will continue during this hearing, I'm sure. Let us not forget two things, Your Honor. Number one, we're talking about a due process right, a property interest in a license that belongs, in this case, initially to the plaintiff. Now, what happened, you can't forget that, and we talk about notices and so forth. When this occurred, when the Detroit Police Department contacted MCOLs and requested that Mr. Martin's license go inactive, it did that, I believe, after the plaintiff had pled to certain misdemeanor charges that he was charged with. And when they did that, the Detroit Police Department notified MCOLs. MCOLs then acknowledged that it was in receipt of this request to make his license inactive. What neither of them did was give the holder of the license, Mr. Martin, notice that his license had been placed on inactive status. So in other words, he had no idea at that time that he did not have an active license. That continued throughout this entire matter. And when pursuant to the agreement that put him back to work because he had been terminated at a chief's hearing, and that was appealed to arbitration. And then the union and the department got together and decided under Chief Craig that he would reinstate him. And they did so pursuant to the agreement that you acknowledged earlier. At that time, he understood that his license was active. So then and that occurred on May 19th, 2021.
Mr. Sednick,
yes.
I'm going to stop you for a second because I have a few procedural questions for
Sure.
you. And just as an education for myself, what was the procedure when Mr. Martin was, or Sergeant Martin was reinstated, and that when his termination was instead parlayed into a suspension without pay?
Okay, I'm sorry.
Go ahead. Was he required to retake the oath of office? Did he have to go through, was there a process through HR in terms of reprocessing paperwork, or was it basically a nullification of the prior termination and the notation was you were suspended without pay, but you're back to where you were?
It was treated as a suspension. There was no obligation on the part of the officer to do anything but sign the agreement. And it really was an agreement between the union and the city through the department to reinstate his employment. So he was reinstated with full seniority, with his rank of sergeant. He just didn't get back pay because they treated it as a suspension. So nothing else was necessary. He didn't have to take another oath of office. The agreement itself says that he's reinstated with full law enforcement authority. Now, it's not up to him to notify MCOs. He can't notify MCOs. It's not permitted. And counsel was right. It was up to the department to do so. It's interesting here because during testimony, the person in charge of licensing indicated that, and this is something that hasn't come up yet, but MCOs has the authority to toll the running of the 2-year inactive period. It can do so if, in fact, it receives notice prior to the termination of the lapse period that an officer has been reinstated. Now, the practice of the department up until that point has always been to notify MCOs within a couple of days of reinstatement that the officer's authority through the department has been reinstated. And had that occurred in this particular case, had they followed that practice, followed that procedure, they would have notified MCOs. MCOs then would have told that running of that period.
Mr. Sednick, your argument is well taken,
Mhm.
but don't you think that that's an argument for a claim against DPD as opposed to MCOs?
No.
MCOs did what they were supposed to do or not do based on information they received from DPD, right?
Well, except for two things, Your Honor. Number one, both MCOs and the department, I believe, denied the plaintiff his due process by never notifying him that his license was inactive. Had they notified him of that date back in June of 2019, he could have been monitoring it. The union could have been monitoring that and knew that in May, when he was reinstated, that they could have contacted or the department to contact MCOs. Instead, the department waited 6 weeks. I don't believe that was unintentional. And here's the problem. The problem is we switched administrations during that from Chief Craig to Chief White. They didn't like the fact that he was reinstated. All that they have to do in order to prevent him from getting an appeal was to say, is to not notify MCOs until the expiration of the 2-year period, at which point it puts them in that retraining status. And of course, it's the claim of MCOs that once you're in that status, you lose your property interest in your license. And if we deny it, you have no right of appeal. So what that means is that, any
That's
department.
after a lapse. Their argument is that
Yeah.
after a lapse, there is no property interest because the license is gone, so to
And
speak.
an department that knows that, and they don't want to reinstate that person, they just sit back and they wait until the time lapses. And they know that by doing that, that officer is not going to have an appeal right because he loses his property interest. That cannot be permitted. I mean, MCOs, through their mistakes, and the department, through its mistake of not promptly notifying MCOs to reinstate his license before the lapse of the period, if they just knowingly, intentionally do not notify MCOs, he loses his right to an appeal. How can that happen under due process and under property right? And you say, well, isn't his action against the department? The department, as we've seen, cannot unilaterally restore his license. MCOs does that. So I can't, can he file a civil lawsuit? He might get damages of some sort, but he can't get his license restored. They've taken
Mr.
that
Sedgwick?
away.
Mr. Sednick, are you conceding then that as a operation of law, Mr. Martin's license has lapsed as opposed to remained inactive?
No, to do that, I would have to say that MCOs just stands there like a large stone and counting days off the calendar. And yet we've had testimony from MCOs that says we have the authority to toll the expiration of that inactive license. And we can do that if the department had notified us, let's say, just before June 2nd, if it had notified us, we would have told the running of that period so that we can then conduct a character and fitness investigation to see if it warrants getting his license back. If under those circumstances, his license is inactive and they conduct a character and fitness examination and decide he's not fit, he gets an appeal. He gets an appeal. And that's all we're asking for in this case, is to allow him to appeal, because you cannot, through faulty decision-making, number one, not giving him notice of the time period when it started that his license was subject to lapsing. He didn't know when that time period began to run in 2019. Nobody told him. Nobody gave him notice.
What is your response to the argument that a plaintiff is deemed to know the law, so that these laws and the are publicly available, and that he should know that if he was facing an adverse employment, the termination, the suspension, et cetera, that he should know if he wasn't fully reinstated with plenary police powers, that impacted his license?
No, Your Honor, you have to remember that the department contacted MCOs when warrants issued. He wasn't terminated or suspended at that time. He was still employed. He wasn't separated till a later date in time. And so he would not have known that the department, when those warrants issued, contacted MCOs and said, put his license in inactive status. He would not have known that. He believed, as we all did, I believe, that his license was active. at that point. Even when he was subsequently terminated, there was an assumption maybe that's the date that starts the running of the 2-year period. But nobody gave him notice. Nobody gave the union notice. No notice went to him. So you had to guess, does he have an active license or doesn't he have? Under those conditions, it's not up to, we knew what the law was. We knew the law said 2 years from the date that the clock starts. What we didn't know is when the clock started, and nobody gave him notice of that. That's clearly a deprivation of due process. You got to give someone notice that you're going to take something away from him at a certain point so that he can act on it.
So that sort of goes back to my prior question that I asked you, which is that, are you conceding the Attorney General's point that that Mr. Martin's license has lapsed under the 2 years?
No, and I get back to this whole idea that MCOLS, by virtue of its authority to toll the running of the inactive period, could have and should have done so when it knew before it made the decision to revoke and not give him a law enforcement license later in 2023. It knew before it made that decision that Detroit Police Department did not notify it promptly when his employment was reinstated. And MCOLS, one of their administrators, admitted on the stand that had the Detroit Police Department followed its practice to notify MCOLS of the fact that he was reinstated and were requesting an active license. Had they done that in May when they reinstated him, his license would not have lapsed. It would have remained in inactive status. And that's my point. If MCOLS has the authority to toll the running, and it knew before they made the decision to revoke his license that Detroit failed to notify it, I believe that given the authority to toll, that it should have exercised that authority. And instead, it was just complacent. It's allowing the department to execute an improper decision, and it just defers to that impropriety. And as a result of that, someone loses their license. So no, I don't agree that his license lapsed. I believe that it only lapsed if by the fact that both Detroit and MCOLS didn't fulfill their duties in this particular instance. And you can't, by a failure to perform your duty, then claim that the plaintiff never had a legal right to continue with an inactive license and had a legal right to appeal the ultimate decision of MCOLS on the basis of character and fitness, which they made later in 2023. And again, that's all we're saying is that he should have had the right on due process grounds to appeal the ultimate decision of MCOLS. Now, whether he is successful in that appeal or not, it's another story, but he has the right to that appeal. MCOLS knew of that decision by Detroit, that it didn't adhere to its practice, that it should have notified MCOLS before the expiration of the inactive period. It knew that when it revoked the license. And how can you rely on MCOLS' failure, number one, not to give the plaintiff notice of when the inactive period started, and number two, when MCOLS knew that Detroit did not follow its practice to promptly notify it? It could have said, you know what? If Detroit had notified us, his license would have been inactive. He would have had the right to appeal our decision.
Mr. Sednick, the tolling argument that you've raised a couple of times today is not pleaded in your complaint, correct?
Oh, yes, it is.
Okay, can you,
I mean, let me go back. I have the complaint in front of me. Yes, I think it starts on maybe page 4 of the complaint, where it talks about the department intentionally, in paragraph 13, intentionally or negligently failed to request active status from MCOs upon the execution of the last chance plea agreement. Consequently, the time period was not told, and Sergeant Martin's law enforcement license lapsed as of June 3, 2021. Number 14, according to MCOs, had a request from the Detroit Police Department to reactivate his law enforcement officer license been received by MCOs between May 27, 2021 and June 3, 2021, the date the license lapsed. The request would have been considered timely, meaning his license would not have lapsed on June 3, 2021, and that's attachment C.
yeah, I have it in front of me. But there's no factual allegation that MCOs actually had notice of this, correct? In order to apply the tolling.
Well, no, yes, it did, because MCOs pursuant, there was an arbitration that occurred with regard to the initial separation, the chief's hearing termination was there was, well, I'm sorry, there was a subsequent appeal to arbitration where MCOs had testified, you know, had it been notified promptly before before June 3 of 2021, that the time period would have been told. They acknowledge that.
Right, if they had been, but there are no factual allegations that they had actual notice of this before that 2-year period. Is that correct?
But
Because I guess if I'm trying to understand your tolling argument, in order for tolling to apply, MCOs would have had to have had notice of the notice from DPD one way or the other. And the problem we have here is that DPD didn't convey that information. MCOs didn't have that information. So the tolling would not apply because they didn't know that there was a situation where tolling could or should apply.
Probably at the time that no, because here's what, now that I'm trying to go back to the facts. Actually, the union reached that agreement with the department. He was reinstated on May 19th. And then from May 19th, 2021 through July 19th, 2021, he worked full duty as a supervisor in a uniform with a badge and gun. So after the so-called end of the inactive period that MCOs says expired on June 3, he continued to work full duty as a supervisor, as a sergeant, in uniform with badge and gun after that so-called inactive period expired. And he worked with
May 9th, I'm sorry to interrupt you, but I think this is important for me to understand. It's one of the procedural questions that I had. So May 19th, he returns to full duty. You're saying that he had his full badge and gun at that point?
He did.
Okay.
And it wasn't until around May, until June 3 that the department apparently did some research and discovered, at least they say they discovered around that time. Maybe the chief discovered that he had gone beyond the expiration of the inactive period. That's when this whole issue.
Hold on, I'm gonna just to make sure that we're on the same page. would this be? So would this be the July 20th inter-office memo that was sent?
Yes, I believe that.
So on May 28th, in lieu of arbitration, the department and Sergeant Martin entered into a last chance plea agreement. The sustained findings, the remaining charges were on May 19th. Sergeant Martin was returned to full duty by the department, and you're telling me that that's when he had his full badge and gun. And then
Yes,
the next paragraph says, on July 19, 2021, a review of the M. Cole's licensing indicated that Sergeant Martin Cole's license is inactive pending a standards compliance review by M. Cole's. Consequently, Sergeant Martin is currently not licensed to perform work as a police officer in the state of Michigan. Based on the affirmation, facts, and circumstances, Sergeant Martin will be carried administrative duty, no gun, effective immediately. So that memo is dated July 20th, 2021. And so your representation is that between May 19th and July 20th, he was carrying a gun and badge and performing all the duties of a police officer.
yeah, and then the memo that you're reading, at that point, they continued his employment, but because his status was that of inactive license at that's what the department believed, and that's what was also conveyed to the plaintiff, was that they couldn't let him out on the street with a badge and gun. They would continue his employment, but do it on the basis of being an inactive license, and he continued in employment. So they didn't say that his license lapsed. Yeah, they believed it was still inactive at that particular time.
Okay.
It was only later, after that, that they then learned of the June 3, 2019 date, and then decided to separate his employment. That went to arbitration, where an arbitrator said, look, they looked at all the facts of the incident for which he was originally separated and terminated, that being the Greektown incident back in 2018, and they looked at that. The arbitrator looked at it and decided that his employment should be reinstated, subject to him acquiring a license from M. Cole's. And at that point, he had been kind of forced into the RPTE process, because M. Cole's then claimed that his license had lapsed, and because it lapsed, he had to go through that process. And as a result of going through that process, when it did a character and fitness exam, it revoked his license and then said, you don't have an appeal because you lost your property right when the license lapsed. And our argument was that you can't, at that point, it did know of Detroit's decision not to timely notify it. When it decided in 2023, it knew that, and if you read the decision of M. Cole's in 2023, you find out that it knew that Detroit did not promptly notify it when he was reinstated back in May of 2021. So at the time that they revoked his license, they knew of that, I guess, failure on Detroit's part to follow protocol or follow its practice to notify M. Cole's promptly about reinstatement and giving him authority to act as a police officer. They knew that before they revoked his license. And my argument was that if you knew that, and you knew that Detroit didn't do it, how do you condone that when you had the opportunity? You could have come back and said, look, because we have knowledge of that mistake that Detroit made, whether intentional or negligence, we're gonna toll the period and allow his license to be inactive. it still gives us the right to do a character and fitness investigation, and we might revoke his license then. The only difference being that he would then have a right to appeal our decision. And we're saying he should have that right to appeal that decision if you knew of Detroit's mistake back in May, and you, in essence, either deferred to it or condoned it. You
What is the
can't,
part of the statute that talks about the right to an appeal versus not having the right to an appeal? Just so that,
it's, I think it's, well, what MCO's claims is that the right to appeal extends to an officer whose license is inactive at the time they make their decision not to provide a license because of a character and fitness investigation. If the license at that time is inactive, MCO's takes the position that there's still a property right in the license, and we have to offer him an appeal. They claim that if the license is lapsed, there's no longer a property right because the officer no longer has possession of a license. It's lapsed. There isn't even an inactive status any longer. So the officer doesn't have a property right at that point in a lapsed license. And therefore, when we deny the right of an officer to have a law enforcement's license, we don't give them an appeal. It does the same kind of investigation, a character and fitness an investigation, as it would for an inactive license. But in the case of a lapsed license, they refuse to give an officer an appeal. And I guess what we're saying is that if you knew at that time that Detroit should have notified you, and it either intentionally or negligently didn't, and you knew that at the time, you could kind of retroactively declare the license to have, or the period to have told, so that the officer would get the opportunity to appeal their decision. You can't take two wrongs to take away the property right. You can't take their failure to give the officer notice right in the beginning of the inactive time period, and then you can't also acknowledge Detroit failed to give you proper notice. And by those two call them mistakes or faulty decisions, whatever you might call them, and use those to give you the right to deny an appeal. How do you do that? Take two wrongs to make a right? On due process grounds, that's pretty faulty to me.
okay. Thank you, Mr. Sednick. Mr. Sands, you have rebuttal?
Yes, thank you, Your Honor. A couple things. I do want to talk about the appeal. Really, we're talking about two different things. We have the Bundo case that we cite, the rudimentary due process for an individual with a license, and an administrative hearing under the Administrative Procedures Act. That's the appeal that he doesn't get because he doesn't have an active license. The appeal he's still entitled to is the one we cite on page, I believe, 15 of our brief.
On page which? What page?
Yeah, page 15, bottom page 15, is an appeal under the Revised Judicature Act, which allows anybody to appeal a final decision of an agency. The difference is it's an uncontested case versus a contested case hearing that you get under the APA. So he's not without a remedy. His remedy is just limited to what's provided in the RJA.
And that appeal would have been taken when the decision was made, right?
Yeah,
that time has gone.
Second,
Please continue, Mr. Sands.
okay, I wanted to make sure. Second, he did receive notification that he was without law enforcement authority when Detroit Police Department took his badge and his gun. The fact he's still employed doesn't mean he's licensed. DPD has any number of unlicensed, unsworn employees in the Detroit Police Department. And Mr. Martin was just in the same circumstances, somebody that broke their leg and can't walk the beat, or broke their hand and can't handle a firearm. He could still be employed by Detroit Police Department. He could still work in an unsworn capacity, and MPOLS has nothing to say about that because we don't regulate the Detroit Police Department. So the fact that he was still employed is irrelevant to his licensure because his license wasn't reactivated. A note on the tolling: the commission's a creature of the legislature. It can only exercise the authority the legislature gives it. The legislature gave it limited authority to toll the lapse period, and that authority is in the Administrative Procedures Act. It says when you're renewing a license or reactivating a license, the time for that license to expire tolls until the end of that litigation. But once it was no longer an inactive license, the commission's authority from the legislature to toll that went away. And what the legislature did instead is it said that if you go beyond the lapse period, you go through the RPTE process. And if you're denied, you go through the appeals process and the revised RJA.
Okay.
But just,
Uh,
can I make one point? Because I'm not certain whether that other appeal process through the Administrative Procedures Act, they have the authority, because MCOLS is the one with the authority to activate a license. MCOLS specifically denied him the right to appeal.
Okay. Mr. Sands, do you have anything in response to that?
I would just simply point to the RJA and note that anybody can appeal an order from an agency. The appeal that was denied was an appeal to have a contested case hearing through the administrative procedure.
I guess it's Mr. Sands saying that through that appeal, they'd have the right to direct MCOLS to provide an appeal, because the appeal through MCOLS is different. The appeal through MCOLS starts with the right to have an administrative law judge make a
Right. I think
determination.
that's what Mr. Sands is saying, that that appeal is through the Administrative Procedures Act and is separate and distinct from the right to an appeal, like just a decision to the circuit court.
I may be mistaken, but I thought the appeal that is available to a person with an inactive license who receives an adverse decision from MCOLS is first to the administrative law judge. You give MCOLS notice that you want to appeal. They then process that to an administrative law judge, and then that particular decision, unlike Merck decisions with administrative law judge, is not binding on MCOLS. And if they don't like the administrative law judge's decision, you have to go to the Michigan Court of Claims. That's the appeal process that MCOLS offers inactive persons who are the subject of an adverse decision from them regarding their license. Now, I don't know about, I don't think that's what we're referring to as the other
I think Mr.
appeal
Sands,
process.
with the lapsed, he's saying that you're outside of the Administrative Procedures Act and that you would be taking an appeal straight to the courts under the RJA.
Under the RJA.
Okay. All right. Thank you both for your argument. We will get an opinion out to you as soon as we can.
All right. Thank you, Judge.
Thank you very much. Thank you, Ms. Harris. Appreciate your help today.
Thank you.